Summary of TCC Judgment 111 Champagne 7, 2022 remedies for defense counsel's right to take notes and other rights during investigation. High notes. The accused or criminal suspect's right to effective assistance of counsel and the right to defense during investigation should include the right of defense counsel to be present, to take notes, and to state opinions. Article 416, Paragraph 1 of the Code of Criminal Procedure and other relevant provisions are unconstitutional for failing to provide the accused, the suspect, or their defense counsel with the opportunity to object or seek remedy against the prosecutor's order to restrict or prohibit the defense counsel from being present, take notes, or express opinions under the circumstances stated in the proviso of Article 245, Paragraph 2 of the Code. Such failure violates the constitutional principle of where there is a right, there is a remedy, thus violating the right to institute legal proceedings under Article 16 of the Constitution. Background notes. I will skip the background facts here. Summary of the judgment holding. 1. Article 416, Paragraph 1 of the Code, and the other relevant provisions did not provide the accused, criminal suspect, or the defense counsel with the opportunity to challenge the prosecutor's order of restricting the counsel from being present, take notes, or offering legal advice in situations listed in the proviso of Article 245, Paragraph 1 of the Code. Within this scope, the disputed provision and the other relevant provisions do not conform to the constitutional principle of where there is a right, there is a remedy, thus violating the right to institute legal proceedings under Article 16 of the Constitution. The competent authority should amend the Code as appropriate within a 2-year grace period as of the announcement of this judgment. Before the amendment, the accused, the criminal suspect, or the defense counsel may apply Article 416 of the Code, mutatis mutandis, and petition the concerned court to withdraw the prosecutor's order in the aforementioned stage situation. The rest of the petition shall be dismissed. Reasoning. Principle pertaining to the review. In accordance with the protection of personal freedom and the right to institute a legal proceeding under Article 8 and 16 of the Constitution, the accused should have the right to a fair trial following the due process of law, which especially entails the right of sufficient defense during trial. The constitutional protection to the due process of law and the right of sufficient defense should not be limited to the accused sub judice, that is, under the judgment under the court's trial day, but it should be effectively offered to the criminal suspect starting from the stage of investigation. So sub judice is kind of the stage of trial. Such protection should include the accused or criminal suspect's right to effective assistance of counsel. The defense counsel, to protect the accused or the criminal suspect's right effectively, should have the right to be present and provide this legal instance or legal assistance in a timely manner when the accused or the criminal suspect is under the prosecutorial interrogation during the criminal investigation process. So that is before or the trial stage, that is under the investigation stage, and it is about the prosecutorial interrogation. This entails that the defense counsel has the right to be present during interrogation, and the counsel can express opinions as well as to memorize, comprehend, and engage in other thinking activities. Taking notes on the spot is auxiliary to such activity and is inseparable from the defense counsel's conduct of being present and offering advice on site. Therefore, in addition to the right of choice of counsel, the accused or criminal suspect's right to effective consistence of counsel and the right to defense during investigation stage should include, at a minimum, the right of the defense counsel to be present, to take notes, and to state opinions. The defense counsel should have the right to seek remedy in his or her own name, that is, in counsel's name, for the benefit of the accused or criminal suspect unless explicitly indicated otherwise by the accused or suspect. Second, judgment of the court. Article 245, paragraph 2 of the code stipulates the defense attorney of an accused or suspect may present and state his opinion. When the prosecuting investigator, judicial police officer, judicial policeman interrogates the accused or suspect. However, such presence may be restricted or prohibited if there are sufficient facts to support the belief that the defense counsel's presence may jeopardize national security, or may destroy, fabricate, or other evidence, or may collude with the accomplices or witnesses, or may damage other people's reputation, or the defense counsel's misconduct is sufficient to affect the order of the prosecutorial investigation. The proviso clause of this provision explicitly states that under certain circumstances, the prosecutor may restrict or prohibit the right to have a counsel of the right to have a counsel. The right of the counsel of the accused or the suspect or the defense attorney during investigation at the stage of criminal investigation. Such a measure may constrain or deprive the accused or criminal suspect's constitutional right to effective assistance of counsel. However, there are no corresponding judicial remedy available under the current code. There are no corresponding judicial remedy available under the current code of the criminal procedure. The disputed provision and other relevant provisions of the code did not provide the accused or the suspect or the defense counsel with the opportunity to object or seek a remedy against the prosecutor's order to restrict or prohibit the defense counsel from being present, take notes, or express opinion under the circumstances stated in the proviso of Article 245, paragraph 2 of the code. Within this scope, the disputed provision and other relevant provision do not conform to the constitutional principle of where there is a right, there is a remedy, thus violating the right to institute legal proceedings under the Article 16 of the Constitution. The competent authority should amend the code as appropriate within a 2-year grace period as of the announcement of this judgment.